This is a lecture for professional responsibility, and we're going to be talking about Model Rule 6.5, ABA Model Rule 6.5. Now, the sixes, the rules that start with 6.1 to 6.5, all relate to lawyers doing pro bono work or serving on the boards of nonprofits or advocating for reform of the legal system. And they're not heavily tested at all on the MPRE. And the exception seems, if there is one, is 6.5. I would encourage students to just read through 6.1 through 6.5 at least once before the MPRE. Most of these rules are pretty straightforward and obvious. There will be an occasion later in the course to talk about 6.2, about declining judicial appointments. 6.5, though, overlaps with conflicts of interest and is worth talking about for a moment here. And in recent years, the MPRE has included at least one question about 6.5 and its overlap with conflict. So let's take a look at this. A lawyer who, this is at 6.5a, under the auspices of a program sponsored by a nonprofit organization or court, provides short-term limited legal services to a client without expectation by either the lawyer or the client that the lawyer will provide continuing representation in the matter. One, is subject to rules 1.7 and 1.9a only if the lawyer knows that the representation of the client involves a conflict of interest. And two, is subject to rule 1.10 only if the lawyer knows that another lawyer associated with the lawyer in a law firm is disqualified by rule 1.7 or 1.9a with respect to the matter. And B, except as provided in A2, 1.10 is inapplicable to representation governed by this rule. And so hopefully by now, if you've already watched my lectures about rules 1.7 to 1.9 and 1.10, you can see why it's relevant to talk about 6.5 since it incorporates those rules by reference and essentially functions as an exception. And I want to go back and we're going to explain what is this rule about. So a number of either state bar associations or local courthouses have a program, and I'm going to call it the Saturday morning pro bono workshop or something like that, where lawyers can go and volunteer to do short consultations for half an hour or an hour at a time with pro se indigent litigants. And so the idea is that sometimes there's a lot of stuff that people could do by themselves in the legal system, sort of simple legal issues where they just need to file the forms. And a lawyer could kind of tell them what to do and how to represent themselves. And an initial, just a short half hour or hour session with a lawyer is all that they really need. And so lawyers will go and volunteer their time. And what happens in these situations, and these are pretty common actually in our big cities in the United States, lawyers show up, and a lot of times they're on Saturday mornings, but it could be all day Saturday or other days of the week or a Wednesday afternoon. That the time doesn't matter, but there's a scheduled time during the week, and they put the word out on the street, and especially to the homeless population in the city, but also to others, that they can come and get a quick consultation with a lawyer who's not going to take their case, but will kind of tell them how to do it themselves at that time. And then the lawyers volunteer, and this is part of their volunteer work or pro bono work in a sense, except they're not taking on pro bono clients. And that's why the model rules don't call it a pro bono, taking on pro bono clients, because you're not agreeing to represent the person. You didn't meet this person at all. You show up at the courthouse at the scheduled time, and they have a line of people, and they just assign, okay, you're next in line, you go talk to that lawyer. Okay, next person, that lawyer is free in that room over there, that conference room over there. And you may see 10 people in a row for quick consultations. And one person may be filing their Social Security disability appeal, and another person's doing a name change or dealing with filing an appeal with the Veterans Administration, and another person may be facing an eviction or something like that. And so the ABA wants to encourage lawyers to do this, volunteer your free time. They tend to schedule these at times when a lot of lawyers could come if they were willing to. and provide quick consultations. And so now, having explained that, I want you to look at the rule again with me for just a moment. Basically, if you are doing this and it's not on your own, like you didn't set this up, but the court or a nonprofit like Legal Aid or the Bar Association or the Access to Justice Foundation, somebody like that is doing these kind of sessions of almost like speed lawyering, let's say, of short-term limited legal services, and neither you nor the other person expect that you're going to represent them in the matter on an ongoing basis. The bottom line is, and if you don't get anything else, you do not have to screen for conflicts of interest with everybody who pops in for their half-hour turn or 1-hour turn when you show up at the courthouse to do this. And so, and again, it doesn't have to be done at the court. This could be done at the local YMCA or a homeless shelter or a soup kitchen or something like that. And these are pretty common. And you don't know who you're going to see, and you are probably never going to see any of those people again. And so you don't have to screen for conflicts of interest, even though you're giving legal advice to them. And basically, we've carved out, I hope you see, 6.5 is functionally a very significant carve out to the conflicts of interest rule. Also, we're not going to apply 1.9a about switching sides in a matter or something like that. And then here's our exception to the exception. Unless as soon as a person sits down, you quickly realize that you have a conflict of interest. So if you know immediately that you have a conflict, so they sit down and they say, hi, I have a complaint against Conglomerate Corporation, and you realize, wait, I represent Conglomerate Corporation, then don't do that consultation with them. But if it's not an immediately obvious conflict, you don't have to do conflict screening for this narrow circumstance where you are volunteering to do these short sessions, and it's been explained, and usually they even have people sign a written sort of disclaimer that they understand that the lawyer is not going to, whoever they get to talk to is not undertaking representation for them. They're doing a quick consultation of how to do the case themselves. So that's our first part. And under 2, we also aren't going to have to screen you, right? So 1.10 is not going to apply unless you suddenly realize as you're talking to them that even though you don't have a conflict, there is one other lawyer in your firm who has a conflict of interest and so forth. And then we are going to get into 2. But generally 1.10 also doesn't apply. And this is why we're talking about it in the context of conflicts of interest. You need to be aware that in other settings, when you do an initial consultation with someone, even though you don't continue with the representation very long, or maybe you withdraw pretty quickly, you could, in theory, even with a single consultation, implicate the conflicts of interest rules and implicate representation. And you have undertaken the provision of legal services, but even by doing a quick session for people. But we have basically said, because you're doing this under the auspices of a program, and we don't want lawyers to be deterred from volunteering for these because they're worried about the conflicts issues, right? Imagine if conflicts did apply, and you're going to see 10 people in a row or 20 people in a row every week when you go and volunteer. That's a lot of conflicts baggage to accrue. And you're not getting compensated for it. So it's something to think about. And this ends up being, and they do ask about this on the MPRE. So comment 1 basically just explains what everything I've just said, that legal aid clinics, sometimes courts and other types of nonprofits set up these programs at a time when they think lawyers can come, and they put word out on the street that if somebody has a legal matter and they need to talk to a lawyer, but they are going to have to handle it themselves, that they can come in for that consultation. Please note in comment 1 at the end, it says, in these programs, such as legal advice hotlines, that would be another one. Sometimes lawyers, you're not meeting face-to-face, but you agree to go in and take phone calls at a certain time of day to man the phones for people who call in and have a legal problem. Advice-only clinics or pro se counseling programs, a client-lawyer relationship is established. This does mean, for example, that if you gave somebody fantastically incompetent advice, could they sue you for malpractice for that? Yes, they could, right? Because even though it's a quick consultation, you're providing legal services in a limited capacity, even though there's no expectation that the lawyer's representation of the client will continue beyond that consultation. These programs are normally operated under circumstances in which it's not feasible for a lawyer to systematically screen for conflicts of interest as is generally required. So, right, it's not feasible for you to screen for conflicts while you're there at this place, taking whatever phone call gets transferred to you because you're doing a phone-in hotline or meeting with people who have come and lined up waiting for their turn to talk to a lawyer. Comment 2, a lawyer who provides short-term limited legal services pursuant to this rule must secure the client's informed consent to the limited scope of the representation. And so there's no question that you will have to communicate clearly to the person that this is a consultation, a one-time consultation only. It's very limited, the scope of what you're doing, and you're not taking the case, and they have to agree to that. If short-term limited representation would not be reasonable under the circumstances, you can't offer advice. And so if they have a very complicated case that would require you to do a lot of document review or talk to some other witnesses or make some phone calls, then you're going to have to tell them, I'm sorry, your legal problem is complex enough that it's not suitable for one of these quick one-time consultations. By the way, the confidentiality rules do apply. Note that too on 1.6 and 1.9c. So if you go and do one of these clinics or something like a Saturday morning pro bono clinic where you're seeing people one after another, talking to people, doing these quick consultations, you still have to keep whatever they tell you confidential. They should have an expectation that you're not going to go tell other people or tell the adverse party in their case. Because the lawyer, this is comment 3, is not able to check systematically for conflicts of interest, we don't require compliance with 1.7 or 1.9a unless you happen to already know that there's a conflict. And how would that happen? They mention another party involved in their legal matter when they're doing their consultation who you represent, or something like that, where it's immediately evident to you that you have a conflict. And similarly, comment 4 just restates the point that 1.10 is inapplicable to these quick one-off consultations. Again, unless we know. But this part of comment 4 is more significant, and I want to make sure I have it all in bold. I want to draw your attention to it along with the rule. By virtue of paragraph B, a lawyer's participation in a short-term limited legal service program will not preclude the lawyer's firm from undertaking or continuing the representation of a client with interests adverse to a client being represented under the program's auspices. Nor will the personal disqualification of a lawyer participating in the program be imputed to other lawyers participating in the program. This means if you go in and you do one of these consultations, subsequently, the rest of your firm is not barred from representing the opposing party to that, let's say, indigent person that you did the quick one-time consultation for. Again, this doesn't apply to one-time people who come into your office who are normal prospective clients who you are considering representing. We're talking about situations where you and this other individual have agreed ahead of time, this is the only conversation you're having. And so please note, this could be a gotcha question on the MPRE. You do a consultation on Saturday morning at the clinic or at the court, at this pro bono session at the courthouse. And then the next week, the other party, you didn't even tell anybody about this, but the other party happens to approach one of the lawyers in your firm for representation. They would not be disqualified from doing that by conflicts. Again, an important exception to the conflicts of interest rule. Also, comment 5 notes, if you want, at the end of your consultation, even though they agreed before the consultation you weren't going to represent them, if by the time at the end of the consultation you say, you know what, I want to take your case, I would like to represent you, you are allowed to do that. And then the conflicts rules do trigger, right? So if you go to that clinic and somebody comes in and they tell you their little story, and you had agreed up front that I'm going to do a one-time advice session for you, and you are going to be pro se, you're on your own. And then as they talk to you, you're like, wow, I want to take this. This is important, or this is huge, or this is really interesting. So then, of course, you're going to have to screen for conflicts. If you're going to undertake a normal representation of this person, there's no rule against it, except that all the other rules now apply.